Bom dia a todos. Eu dou início aos trabalhos deste seminário internacional gostaria primeiro de agradecer a presença de todos, o interesse de todos por essa questão educacional. A semana passada nós discutimos a questão, o fenômeno da corrupção, temas de direito civil, mas esta semana nós, na realidade, nós organizamos um seminário que é a segunda parte de um seminário maior, de um encontro maior. Os primeiros dois encontros, segunda e terça-feira, tiveram lugar na Faculdade de Direito do Largo São Francisco, e a terceira parte e última parte deste seminário será realizado aqui, também Faculdade de Direito, também USP, mas aqui em Ribeirão Preto. E eu trouxe toda a formação para cá, para discutir essas questões extremamente sensíveis, extremamente delicadas, todas pertinentes à questão educacional. Como vai a educação? Mas não é como vai a educação aqui no Brasil, como vai a educação no mundo. Este é o nosso problema e este é o nosso tema. Na realidade, o que se está perseguindo é a educação de qualidade. O que nós não conseguimos transportar aqui para Ribeirão Preto, na realidade, foi a equipe de Todos pela Educação, que é uma ONG que atua no sentido de conquistar qualidade no setor educacional, financiamentos próprios para elevar a qualidade da educação. Todo este grupo, o grupo de pesquisa conduzido sob a liderança da professora Nina Raineiri, aqui entre nós, e eu tenho a honra de participar do grupo de pesquisa, realmente como pesquisadora, como professora aqui da escola, da USP, mas todos nós estamos quase que, eu diria, dissecando a questão educacional, procurando investigar como podemos alcançar uma educação efetivamente de qualidade. E isto é uma preocupação que, na realidade, não é uma prerrogativa nossa, brasileira, doméstica, mas é uma preocupação, é um dilema que se assenta em todo o mundo. Hoje nós vamos até, no final deste encontro, nós vamos sortear este livro, Reflexões sobre Justiça e Educação. É um livro que foi produzido com a colaboração da equipe da professora Nina Raineiri, mas foi um esforço de Todos pela Educação e da editora Moderna. Este livro foi lançado na segunda-feira, ou na terça-feira, não? Segunda-feira, numa das sessões, vamos dizer assim, deste seminário internacional, e eu vou, num primeiro momento em português, apresentar aqui os nossos expositores, e, num segundo momento, já começando em inglês. Mas quem estará aqui participando é a professora Nina Raineiri, é a professora associada da Faculdade de Direito USP São Francisco, da capital. A professora Nina comanda, integra Todos pela Educação, tem uma interface muito de perto com essa ONG, é especialista em educação e tem produzido vários trabalhos sobre o tema. Na realidade, ela também ofereceu gentilmente aqui para a nossa biblioteca vários livros, e pelos livros de autoria da professora Nina, que estarão daqui para frente na biblioteca, vocês vão ver a especialidade dela na questão educacional. E, a partir daí, eu vou ter o prazer também de anunciar a presença e a fala da professora Susanne Equis. Ela é professora da Universidade de Indiana, da Faculdade de Educação. Portanto, vejam vocês que nós estamos num campo interdisciplinar. Nós não estamos apenas caminhando, e tão somente caminhando, no setor da juridicidade. Nós estamos nos afastando para também entrar no campo educacional. Tanto a professora Suzanne quanto o professor Charles Russo, que eu apresento logo em seguida, são nossos velhos amigos, velhos conhecidos. Nós participamos de longos debates, principalmente sob a condução, a direção e a orientação da professora Nina, a qual eu me submeto neste campo. E o campo é dela, a especialidade é dela, e eu entro com as minhas ideias de Constituição, e eu realmente... Mas, em todo caso, o professor Charles Russo é da Universidade de Dayton. E tanto a professora Suzanne quanto o professor Charles Russo vão apresentar para vocês a visão norte-americana sobre essa questão educacional, a qualidade educacional, métodos, técnicas, medidas, atividades e atos para aprimorar a qualidade na educação. Ainda fazendo parte do grupo internacional que nós convidamos aqui para tratar deste assunto tão delicado, o professor Michael Gregory. O professor Michael Gregory é da Universidade de Harvard e, na realidade, pela primeira vez, ele tem essa interface com a educação entre nós, aqui no campo doméstico brasileiro. Pela primeira vez, participa de um seminário e, na realidade, a minha impressão é que ele sai daqui do Brasil com a melhor das impressões sobre o nosso trabalho, pelo menos o nosso trabalho no campo jurídico, e a partir dessas ONGs que atuam nessa plataforma, no sentido de alcançar cada vez mais uma qualidade diferenciada. Por fim, eu tenho a honra de apresentar aqui o Marcelo Mazotti. O Marcelo é doutor recente pela Universidade de São Paulo, sob a minha orientação, e foi a pesquisa dele, principalmente realizada durante 6 meses consecutivos nos Estados Unidos, em Indiana, sob a orientação da professora Suzanne Eckes. Então, mas foi a pesquisa dele que me levou, efetivamente, quase que me obrigou a me debruçar sobre o setor educacional, porque, na medida que eu aceitei orientar, eu tinha que saber mais que o orientado. Então, vejam só o esforço que eu tive que fazer, realizar, mas hoje em dia tenho uma grande satisfação de ver o doutor Marcelo Mazotti aqui na mesma mesa e participando de um seminário internacional. Pois bem, I have the pleasure to present to you this seminar, Brazil and USA, Perspectives, Federalism, Judicial Activism, and High Quality Education. This seminar and the members of this table are Professora Nina Raineiri, Nina Beatriz Raineiri. She is associated professor at the University of São Paulo Law School, but the law school from São Paulo, the capital campus. And after that, I have the pleasure to present you Professora Suzanne Eckes from Indiana, Professor Charles Russo from Dayton University, Professor Michael Gregory, clinical professor of law at Harvard Law School. And finally, I want to present you Marcelo Mazotti. In the first place, will talk. And I have the pleasure to pass the word to Professora Suzanne Eckes. Professora Suzanne, please.
Thank you very much for that introduction and for the invitation. I have been to Brazil. I think this is my 4th time, but my first time at your university. So I am really happy to be here and appreciate all the warm welcomes and the organization of this conference. So thank you very, very much. As Professor Monica said, my name is Suzanne Eckes. I'm a professor at Indiana University, where I'm in the School of Education, but I teach classes that are cross-listed with the School of Law and at the Kelley School of Business. But my focus in my research is on education issues and how the law can impact school policy. And I'm most interested on how laws around historically marginalized groups translate into policy in a school classroom. So before I begin, I just want everyone to know you can stop me at any time and ask me questions, and I'm happy for this to be interactive session. So anytime, please feel free. I'm going to go fairly quickly through the first few slides and spend most of my time on discrimination around sex and gender, because I do only have 30 minutes and I have a lot of slides. So again, kind of this overarching theme is how the law impacts the rights of students who have been historically marginalized and access issues within education. So within the US context, we have federal laws created by our US Congress. We have constitutional law stemming from the US Constitution. We have state laws, we have guidance, we have school policies, many different sources of law and policy that would impact a public school classroom. So I could focus on many other topics in addition to race, ethnicity, disability, gender, sex, undocumented students, English learners, to include students who are experiencing homeless, students who are incarcerated. There are many, many marginalized groups, but with 30 minutes, I had to be very choosy and the areas that I would emphasize. So just very quickly, and I went over this yesterday, and I believe my first presentation I learned is on YouTube. Now I'm famous, I'm a YouTuber, right? That you can see this first presentation with regard to discrimination based on race. So I'm just gonna very quickly go through these slides, but I think most of you probably are aware that in the US we have the Brown versus Board of Education decision from 1954, and it held that separate but equal schools, separate based on race, that violated the US Constitution, in particular 14th Amendment's Equal Protection Clause. And so from 1954 on, the law of the land, because the US Supreme Court is our highest court in the nation, in theory, schools were supposed to be racially integrated. Public schools were supposed to be racially integrated. So I'd just like to point out that pre-1954 in the US, we had state-sponsored segregation. There were laws in place that prohibited students of color attending school with Caucasian students. But even with the Brown versus Board of Education decision in 1954, all the way up through today, we still certainly have racial segregation in the United States. And why is that? Well, the Brown versus Board of Education decision was addressing de jure segregation, and we still have, unfortunately, de facto segregation, oftentimes based on where parents may choose to live in segregated neighborhoods, and the students then choose schools in their neighborhood, which could create, of course, segregated environments. It's much more nuanced and complex, but I do have 30 minutes, but you should feel free to stop. Are there any questions so far? Anything that I said yet? Okay. Am I speaking too fast? my American students tell me, slow down and lay off the caffeine before you, no Diet Coke before our lectures. So after the 1954 decision of Brown versus Board of Education, many schools really ignored the Brown versus Board of Education decision. So as I mentioned yesterday, just very quickly, we had something, a lot of schools adopted something called freedom of choice plans, where white students could choose to go to the predominantly black or made up of students of color public schools, or black students could choose to attend the predominantly white institutions to try to integrate the student body, and that did not always work so well. And then to further ignore the Brown decision and try to circumvent that decision, we had white private academies open where white students paid tuition to attend a private school where they wouldn't have to attend the traditional public schools, which were now racially integrated. And during this time, you saw quite a battle over state rights versus federal rights, which feeds into what you're studying, it sounds like, and part of this course. Just as an FYI for your information, here's a great video clip that is a really interesting take on the Brown versus Board of Education decision, if you happen to be interested in this topic. And then finally, I just want to point out, as I did earlier, 1954 was Brown versus Board of Education. There's a lot of researchers out there who are showing that racial segregation in US public schools in certain parts of the country continues to be quite prevalent. And I should have pointed out yesterday too, it's not just a black and white issue. There are researchers that have documented segregation of Latino and Latina students, as well as African American students. And some have relied on the Brown decision in their research on segregation of students with disabilities, segregation within disciplinary policies, et cetera. This decision has been relied upon quite a bit. Just switching gears just very quickly, I know in Brazil, kind of related to this issue of racial inequity, that you are debating issues around affirmative action policies or race-conscious admissions policies. Well, in the US, it's still a pretty highly controversial topic as well. And we don't do, I know in Brazil that you have a quota system. Marcelo studied at IU for 6 months, and we had many conversations of the difference between, he studied at my university, IU, Indiana University. We had many discussions around the differences between the affirmative action policies in Brazil and the affirmative action policies in the US. In the late 1970s, the US Supreme Court found that quotas in our country were unconstitutional. You can still consider race in admitting students, let's say, into a law school, but race has to be considered very flexibly. The plans have to be narrowly tailored, where it can't be the only factor that's considered. You consider many factors when you're admitting someone into a school of law, not a quota, and not if you're Latina, you get 10 points, and if you're Native American, you get 15 points. No, it has to be considered very flexibly within the admissions process if they so choose to do that, to try to create a diverse environment, because as the research shows me, and as I've experienced a diverse classroom, many educational benefits flow from a diverse classroom. Here are just some of our major US Supreme Court cases that address race-conscious admissions and affirmative action. The third bullet, parents involved, is a K-12 case. The others are higher education. The most recent is Fisher versus University of Texas that addressed affirmative action. And since that time, in the same way that the Brown decision didn't completely settle the issue of racial inequity in K-12 schools, the Fisher decision gave us some great guidance as well to say that race still could be considered as one of many factors, and very flexibly in higher education admissions. There are still openings for litigation, and in fact, Mike is a professor at Harvard Law School. Harvard is undergoing right now a legal challenge by a group of Asian American students who say that the affirmative action policies in place at Harvard discriminate against Asian American students under using a constitutional argument under the 14th Amendment's Equal Protection Clause. So even though in the US, whether we're talking about desegregation or we're talking about affirmative action, we have many different sources of law that come into play. It doesn't mean that the issues are well settled at all. Any questions? Yes? Right.
Or, example, scholarships in private universities. But my question is, do you think the Supreme Court is hard to change the mentality, like in the United States, accept the idea that they have problems to black people or marginalized people to enter in the best universities, or is not the idea, do you think the Supreme Court not change? Because I have read some...
Sure, it's a great question. Right. No, that's a great question, and you're absolutely, you have a great knowledge about the situation in the U.S. When you read some of these cases, a lot of the focus is on diversity, and diversity within classrooms, and diversity, even beyond race, is very important for classrooms discussions, whether it's in the college classroom or in a K-12 classroom, that it brings a lot to the table in terms of your educational experience. So many of these, the language in these cases addresses diversity. Less so, the cases address the historical, and I think this is what you're alluding to here, is the historical discrimination against certain groups in the US and in other countries. It sounds, you're dealing with similar issues here. That after years and years of inequitable policies, of separate but equal policies, of inequitable funding at the K-12 system that lends itself to, where I teach in Indiana right now, we have one school district that would be considered a very wealthy school district, and 15 minutes away, a very poor district where they're not getting as many resources or experiences as the wealthier school. So how is that fair then for those students who attend the very poor school to be on an equal playing field with the wealthier school districts? So that is certainly considered, and it's something I wish that was paid attention to a little bit more, certainly having been a high school teacher in a school district before I was a lawyer, before I was a professor, where it was a completely inequitable system, that my students who were in high school were probably equivalent to where my son is right now in the 7th grade in terms of academic abilities. No fault of their own, but a fault of an inequitable system. Does that answer your question? I don't think it's up to the U.S. Supreme Court to change that mentality. It starts on the ground with, many of these cases, whether it's, I'll touch very briefly on special education law, whether it's desegregation, whether it's gender discrimination, sex discrimination, often starts on the ground with people pushing for changes to state laws and federal laws. And until we have more of a push there, but there certainly is a push there, but right now the focus, I would argue, I don't know if Charlie would disagree with me, is more on the issue of diversity than that very important issue that you raise. Okay, just very quickly, oftentimes our U.S. Department of Education issues guidance on different topics, whether it's on race discrimination or sex discrimination or special education law. And what the U.S. Department of Education is doing, it's not the force of law, but it gives guidance to what the courts and the laws have said on a particular topic. Many of these guidances have been rescinded under the new presidential administration. Yes?
I wonder about people who are mixed race. How does the government deals with that? Like, if the parent is black and the mother is Latino, do they like check both boxes? Does it make a difference for them, or?
You know, I think with regard to college admissions, and you can correct me if I'm wrong, Mike or Charlie, but you're absolutely right. There are mixed races, and maybe you don't fall under that specific box. I've seen a lot of times, and I think it's different for federal forms, but for sometimes admissions programs, they'll have a box that says other, and sometimes we'll let you write that in. I don't know if you have anything, if you disagree with me on that, or yeah. So I think that it's addressed that way where you can write that in.
But like, I don't know how it actually works, but I know there is like a part of like 10% of the spots in the university are for black, others, like they separate this, and then how do they, you know, this person will fall into the black category or the person will fall into the Latino category?
We don't do that. It's just considered very flexibly. So for example, let's say that I was on the admissions committee for your law school, and we were operating from the American policy that's in place interpreting these US Supreme Court decisions or what the guidance says. If I was on your admissions committee, I would look at, what's your grade point average? How'd you do? How are your grades in high school? What are your test scores? Do you have work experience before you got into law school? Oh, you want to be an environmental lawyer and you volunteered at the Equal Protection Agency for 3 years? That's really interesting. Oh, both of your parents died in a plane crash when you were 2 years old and you were raised in an orphanage, but yet maybe your grade's a tiny bit lower than the next application, but you overcame some very difficult they look at all sorts of different things depending on the school and depending on the admission standards. And so they wouldn't necessarily say, and that's actually illegal to say, this many black students, this many Latino students, this many Asian students, this many white students. But some argue that we're still doing that, and I think that's why we have this lawsuit. It's much more complicated than that with the Asian American students in the US saying that they're being displaced in our admissions process. Does that make?
Yes.
Yeah, okay.
Thank you.
So I am going to skip over my slides on disability law because I know certainly Mike will be covering that issue. And how much? Am I almost out of time?
You have 10 minutes.
Okay. I don't want to go over the time. And so I just am going to very briefly say, 10 minutes, just very briefly. So I said that we have laws that impact policies in schools or in employment in your life. And so I mentioned with race, we have some of the cases that I discussed were based on constitutional law, 14th Amendment, Equal Protection Clause. And then I spoke a little bit about affirmative action. With disability law, which you'll hear from Mike a little bit more, and maybe even some from Charlie, is that we have 3 main federal laws that address access and discrimination against students and individuals, even employees, not all of the laws address employees, but we have laws in place, federal laws that were passed by Congress that address access issues for those with disabilities, to access the curriculum, to access the school. Does that translate perfectly into policy now that we have these laws that allow for more access of kids with disabilities to enter school? Does it mean that everything's all wonderful? No. There's a lot of many legal challenges, litigation around, are you providing enough for this student with a disability? Are you following the letter of the law or the regulations? So I think Mike will walk you through a little bit more of that. So I'm going to just very briefly go over disability. But we do have 3 federal laws, and here they are, the ADA, Section 504, and IDEA. This is the most, I would say, highly litigated area in education law in the United States right now, disability law. And we see a lot of litigation around employee rights with disability law as well. So I'm going to skip this slide because I know it will be covered. I'm going to spend a little bit of time on discrimination and laws around sex discrimination and gender discrimination. So we have a federal law that was passed in 1972 that prohibits discrimination based on sex. And we also, I mentioned the Equal Protection Clause of the 14th Amendment that has been used in the race cases and even the disability cases. That constitutional amendment is also at issue with sex discrimination. So Title IX, our federal law, is viewed quite broadly. We have questions that arise in the US. Can we have all girl classrooms, all male classrooms, single sex public schools for girls, for boys? Can we do that? Or is that a violation of Title IX? Is that a violation of our federal law? The regulations of our federal law were amended in 2006 that allow for, maybe not as clearly as some would like, single-sex classrooms, single-sex public schools. But you have to have an exceedingly persuasive justification to segregate that way. And it can't be, oh, well, boys are typically a little rougher than girls, and so they need a nicer teacher, where the boys need to be more, you can't stereotype that way, and there's plenty of research that just shows that that's completely ridiculous. So there have been some legal challenges around these single-sex classrooms under our federal law. So we have federal law that says no discrimination based on sex for those educational institutions that receive federal funds, but still many legal challenges. Also around protections with bullying and harassment related to sex. Title IX can come into play there. The Equal Protection Clause of the 14th Amendment comes into play there. Even though education is a state issue generally in the US, these federal laws impact state issues and local issues in schools and in the workplace. So then I just want to quickly touch upon too that who do you think, related to bullying and harassment in schools, who often gets bullied and harassed in a school more so than other students? Students with disabilities, gay, lesbian, bisexual, transgender, students, questioning students as well. And so with regard to Title IX, that has been used when the discrimination is harassment's based on sex. In the same way, I just showed you the federal laws with regard to disability law. Those laws have been used when students have been bullied and harassed in schools. That's disability discrimination, perhaps under Section 504 or the ADA. We're seeing more and more of those cases recently. So I have about 5 minutes left maybe, or am I done? 5 minutes. Okay, 5 minutes. Let's spend 5 minutes on a topic that is getting a lot of attention right now in the US, and I know that you've had some controversy in your country as well. Transgender students. So look at this scenario right here. We have Cal was assigned the sex of birth at birth of female, but now he's in the 6th grade. He identifies as male. His doctor and psychologist diagnosed him with gender identity disorder, and he's been starting to take hormones, and his friends, his family refer to him as Cal, which is a male name, typical traditional male name in the US. His friends are treating him this way, using pronouns that are male. He now asks his school, can I use the restroom that aligns with my gender identity? I look like a boy, I act like a boy, I identify as male, even though I was assigned the sex at birth as a female. Can I use the male bathroom? So this issue is interesting because we have Title IX that prohibits discrimination based on sex. But when you read the regulations, it does allow for bathrooms to be separated by male and female. But it doesn't address where does a transgender student fall. Well, Cal identifies as male. So is he male under those regulations? Under the Obama administration, they issued guidance to say, based on their interpretation of Title IX and past case law, Cal should use the restroom that aligns with his gender identity. The Trump administration rescinded that guidance. We don't have a U.S. Supreme Court case on this topic. We've had 2 federal circuit court cases that have addressed this. Most recently, some federal district court cases. The general trend is that there's certainly favorable outcomes for the transgender student to be able to access the restroom that aligns with his or her gender identity, but no clear consensus yet. So it's still a topic of confusion. So could someone give me a few reasons why wouldn't we allow Cal to use the restroom that aligns with his gender identity? Excuse me? Prejudice, yeah. You know, we talk about this in my courses that I teach, my education law courses, and some students did some research and they found, I think it was an article from an Arkansas newspaper that said, you know, in the 1950s, people didn't want to use restrooms with African American students because they felt that that was unsafe or that it could spread venereal disease. And some of my students are drawing some parallels between the prejudice that perhaps exists now with this particular issue as well. So thank you. That is a very good point. Yes? Yes, that he needs to preserve his dignity. Yes, and when you read different court cases, they talk a lot about this human rights and dignity of an individual like Cal. You also see research from the medical community that discusses how when transgender students aren't allowed to use a restroom that aligns with their gender identity, they hold their urine all day, they don't use a restroom, and that creates medical issues with urinary tract infections. The students feel ostracized, stigmatized, higher rates of suicide, higher rates of depression. So this is just another interesting area that's evolving in the US. It sounds like in the Brazil context, you haven't had this issue so much in schools as much in a shopping mall, maybe, I've heard. Yeah. So this is an area that I'm watching and many people are watching, even though it is a small percentage of the population, it does have implications. And as former Vice President Joe Biden said, it's the biggest civil rights issue of our current time. So.
Thank you, Professor Suzanne Eckes. I'll pass the word so to Marcelo Mazotti, and the second one, and only for 30 minutes, please.
Okay. First of all, I would like to thank Professor Monica for giving me this opportunity to address you all here. It's such a beautiful university with, I can see a lot of great students eagering to show their positions and their questions, which is very nice. It's been not only a big responsibility to do a PhD with Monica, but also a great privilege. And it's been also a great privilege to work with Professor Nina. My PhD wouldn't exist if it weren't for her, and everything she has done for educational law in Brazil, which is incredible. I mean, what she's doing to development of education law in Brazil, it's without precedent. So I really would like to thank you. Thank you, Suzanne Eckes, too. She's so receptive and welcoming in IU University. USP has an agreement, and we are trying to do new agreements that we could take students from Ribeirão Preto also to Indiana University, so we can keep this dialogue open. I'm gonna tell you guys a little bit of how my dissertation started, how it finished, and how my end of line is not really an end, it's a new beginning. I started with a question a little bit similar to the one our friend asked on the judicial activism and the role of the Supreme Court. In Brazil, we have a lot of litigation about daycare access. So a lot of prosecutors are filing lawsuits demanding free public daycare for poor people. And what we have seen the last years is we are having some improvement, but sometimes the judicial decisions, they are highly ineffective. We have a Supreme Court decision saying every student is allowed, every child is allowed to have a daycare, a free public daycare, but we know that not every municipality is providing it. So what's the value of this Supreme Court decision if it cannot reach every single community? Is it valid? Is it invalid? Is it effective? Is it disrespectful? How do we deal with that? So keeping that in mind, I went to the US because they have a tradition of judicial activism, especially regarding the Brown case. That's what got my attention. The Brown case was decided in the 1950s when they said no more segregation in public schools, so white and blacks should be together. And after that decision, we could think that the segregation was over, but as Suzanne points out, it's not over. So many schools still disrespect that decision. There are still many segregated schools. And one of the ways they find out to try to push the implementation of these schools without segregation was by financial aid. When they have the Civil Rights Law Act, federal funds weren't going to be direct to schools who were segregated. So I started to realize that not only a judicial decision can change reality, but also funding can change reality. And most of all, local communities' consciousness can change reality. So that's why I started my work in a different perspective, because here in Brazil, we have this mentality that maybe some Americans do, that a Supreme Court decision would be the final word on a subject matter. Well, that works in theory, but not in practice. We know that sometimes their decisions are not implemented so fast, and in America, they have a lot of studies of how you have the implementation process, how decisions on federal level are implemented on local levels. So it's a lot of literature that it's hard to find in Brazil. So my main focus was to see how we can do that, especially when we look into our legal framework that is completely different from America. In Brazil, we call ourselves a federalist country. In America, they too. But if we compare both countries, we can't get to the same conclusions. Brazil, in American perspective, would be a centralized country, not a federalist country. And I'm going to give you some examples. When you go to America and you want to study law, please don't make the same mistake I did to try to study the American system, because every state has a different educational legal framework. So you gotta choose, right? You go there, you say, hey, Michael, I wanna study in Boston, so let's keep with Massachusetts law. Or if you go to Indiana with Suzanne, let's study Indiana. Otherwise, you have like 51 different federal laws to study, and they vary completely. For example, in Brazil, our compulsory age is 4 to 17 years old. That's the compulsory school attendance. In America, every state decides when it's compulsory or not. In Brazil, our constitution and our federal laws they decide the legal age. So we have daycare from 0 to 3, we have preschool to 4 to 5, and so on. In America, every state decides what's a daycare, what's preschool, what's high school, etc. We have a federal new law saying that every state must implement full-time high school. You know, in America that wouldn't be possible. It wouldn't be possible to a federal law to decide what states should do in terms of high school. Taxes, that's a very sensitive subject. That is a very interesting one too. In Brazil, we have municipalities have very few autonomy regarding taxes. We have IPTU, they can raise it a little bit. We have ESCS, they can raise it or lower it. But in America, when I was there, that was a real experience. In Bloomington, where IU is located, parents decided through education council to do a referendum in their town, in their county, to raise taxes so that extra money would go to the public schools because public schools were not doing so well. So that is a fantastic example what real federalism and autonomy can do in terms of improving education. And this is something that in Brazil wouldn't be possible. I mean, we couldn't do a referendum to create a new tax. If it's not in the Constitution and it's not in our national tax code, we wouldn't be able to do that. So what got my attention in America is how local communities have power to decide what's best for them and how it can engage society, community, to work together on a better educational system. It sounds a little bit romantic, of course. Sometimes it is idealistic, but sometimes it's real. Many people get engaged in these activities, and I think that's a very important way for you to improve your educational system. We are talking a lot about quality in education, and one of the topics sometimes I hear is that education in Brazil is not going to improve because teachers, they are tenured and they do not have evaluation. So the state of Florida thought the same. They said, you know, we are keeping these teachers, these public teachers here for a lifetime, so they just don't care too much about improving themselves. So we are going, no more tenure. It's a contract, 2 years contract, 1 year contract, and we are going to evaluate you, and then we're going to decide if we are going to give you another contract. Well, that's a great example of how the autonomy can work. I asked an academic from Florida, and their first results were that it didn't improve. It didn't improve the educational system in Florida, but that's a way you can do what Ellis Katz, he always talks about federalism as local laboratories, right? He always talks about it, and I think that's fantastic because every state has its demands, has its needs. Some states may invest more in basic education, some other may invest in universities, and university is another good example, right? I mean, if USP decided to get tuition from wealthy students, it's not possible. I mean, we cannot. Even sometimes donations are being questioned in our judicial system. If as a former student, I would like to give money to the university for a certain purpose, that could be questioned. Why are you giving money, and what are the circumstances? So I think the federalism turned out to be the core topic of my dissertation. It wasn't the starting point. My starting point was the litigation, and I discovered that in America there's no litigation regarding free daycare, although, that's interesting, they do not have free public daycare for everyone. And that fact didn't result in litigation. That's very interesting, but we can discuss it later because I don't have time here. So that was my first study. Then I tried to move on to how the Supreme Court decisions were implemented and turned into effect. But that's a whole new literature that we are not used to. When you do masters and PhD in America, sometimes we deal with a lot of statistics. So you have a lot of studies, numbers and numbers, showing results that we don't usually do here. So I couldn't do that because it was out of I didn't have time for that. So I focus on federalism and how we can improve our system by giving more autonomy to municipalities and states, and then maybe we wouldn't need the Supreme Court to say what everybody should do, because then we could have more collective and social agreement on how we could improve our education. Do you think it's okay? Okay? Okay, so that's it. Thank you all.
Well, Marcelo did marketing about being outside and being at Indiana University and learning how the education is treated in the States. But I am very satisfied because Marcelo is my doctor. I am a Democrat, but I have my doctors and I have my PhDs and my master's MBAs. Thank you, Marcelo. And now is Professor Charles Russo, professor, for 30 minutes. Professor Charles Russo. Professor Charles Russo for 30 minutes. It's yours.
He's reinstalling my PowerPoint. I found a mistake. I just want to.
Do you want to come here?
It might be easier in the middle. If you're interested. Oh, shoot. No, you're good. You're good. Oops, I'm sorry. Where's the clicker? I found a mistake. I was just sitting through it. I found a mistake in my PowerPoint.
Professor, it's yours.
Yes. Okay, good morning, everybody. Bom dia. I apologize for a little confusion. I found a typographical error. Can you hear me without the mic okay? Or do we need the mic? I tend to be pretty loud. I found a mistake on my PowerPoint as I was working through it, so I just changed it with a couple of words in there. I've got 30 minutes that makes me think of an old movie from the United States. It was called This Is Tuesday, It Must Be Belgium. People would go to Europe for 10 days and see 10 different countries and see very little of very many places. And that's the way it is with our Supreme Court. The picture up there is the U.S. Supreme Court in Washington, D.C. Our daughter, had done an internship there. And what I'd like to do with you, there's a flag of Brazil. A little cartoon. I went to a workshop many years ago, said people need something to break the material up. A little bit of a second, kind of like restarting your computer. Well, two kids in a cartoon, Calvin and Hobbes, are a kid and his little pet. I don't want to go to school. I don't want to know anything new, he said. Oh, let me use the mic. Sorry, okay. Oh, I'm sorry, okay. I already know more than I wanted to. I like things better when I didn't understand them. The fact is I'm being educated against my rights. My rights are being trampled. And the cat says, is it a right to remain ignorant? He said, I don't know, but I refuse to find out. By the time I finish, I hope I could answer any or all questions you have on the U.S. Supreme Court. As Suzanne and Mike and, for that matter, Marcelo will attest, you could do an entire lifetime on this topic. And I'm going to give you a real quick overview of a couple things. We were asked to talk a little bit about federalism. And by the way, Suzanne said she speaks quickly. I grew up in a little town you may have heard of called Brooklyn, New York. We talk fast. A little bit about federalism and how the court got involved. Then my favorite topic, but in fact the most widely litigated topic at the Supreme Court involving education, deals with religion in schools. And I know you don't have the separation of state that we quite do. Another cartoon, a little bit dated, but it's still pretty good. My dog ate the Palm Pilot that had the URL of the website my homework was posted on. When I was a kid, kids would say the dog ate my homework. Now the dog eats the computer that the homework is posted on. Student rights, I'm going to go real quickly on that. You can see discipline, due process, free speech. Suzanne talked about Title IX. Mike's going to talk about special education. A whole lot on teacher rights. And finally, school finance or funding education. One case, and I'm going to allude to it quickly, but I'm really going to leave the special ed stuff for Mike here. The 10th Amendment to the United States Constitution is part of the Bill of Rights. And the 10th Amendment was, or the Bill of Rights, is really designed to limit the power of the federal government. And between 1861 and 1865, we have what is called the Civil War. And people often say it was about slavery, but that was the straw that broke the camel's back. It was really about the 10th Amendment. Does the federal government make decisions, or do the 50 individual states make decisions? And if you read the words, the power is not delegated by the United States to the Constitution, they're prohibited to it by the states or reserved to the states respectively other people. In English, or I wish I could say it in Brazilian, it does not mention education. Education belongs to the states, yet most of the cases Suzanne alluded to, a lot of what Mike's going to talk about, all of what I'm going to talk about, are U.S. Supreme Court cases. The U.S. Supreme Court even went so far as to say, in that case about paying for public education, education is not among the rights afforded explicit protection in our Constitution, nor do we find any basis for saying so. So how do you get from a state case to the Supreme Court? I'll mention that in a minute. Underlying all these decisions, we talk about due process. Think of due process as two sides of the same coin. Once you acquire a right, whether to go to school, or to own your car, or to keep your job as a teacher, before that job or that right can be taken away, you're entitled to have procedures, certain steps that are taken before that happens. And that underlies many of the cases, probably all of the cases I will speak about throughout it, and I think also the ones Suzanne and maybe Mike as well. The way Brown versus Board of Education made its way to the Supreme Court was really not about education per se. In Brown, the question was, of course, racial segregation. But states, believe it or not, did not have to provide public schools. But once they opened public schools based on the Fourth Amendment, the last line, nor can they deny any person within a jurisdiction the equal protection of the law. So if you open a school, African Americans, kids of color, whatever term you used to use, and white kids have to go to schools that are equal in terms of what they provide for kids. And in Brown, that was just not the case. I happened to be in Topeka, Kansas, and I remember the date, March 17th, 1991. I remember because my wife was back in New York with my son marching in the St. Patrick's Day parade. But I went to the school that was Brown v. Board of Ed. And the eldest child of the Browns just died about a month ago. The school was just a school still. It is now a museum, a recognition of what it contributed. So I know we're probably using some concepts that may not make sense. If something doesn't make sense or is not clear, please stop me and raise a question. But equal protection undergirds almost everything we're going to talk about. Finally, a brief comment to follow up a little bit on what Marcelo was saying. There's a real debate in the United States. What is the role of judges? Do they make law, or should they interpret law? Should they be activists, or should they engage in restraint? I like to tell people, I like judicial restraint, except when I like activism. That is to say, we all have a basic starting point, but there's going to be a tipping point where we make the exception. And if you're interested at all, I wrote an article that was published in Great Britain almost 8-9 years ago, and the reason I published it there was that Great Britain was considering adopting or having a Supreme Court like the United States has, not just a House of Lords. So I could send it to Professor Monica or Professor Nina, or I'll be glad to give you a card if you'd like to read about it. The justices have changed a little bit, but as Suzanne alluded, as we change presidents, they replace members of the court. And it's not so much the law changes as the attitudes of the 9 people in the front of the courtroom change. There's a body of literature in American law which says that the Supreme Court is kind of a super legislature. It's rewriting laws without the legislative process. It was described by some of the founders as the most anti-democratic of all the branches, but it plays an essential role. Some essentials. Suzanne alluded to something before. I wanted to come back in just a moment. Some early cases, Marbury versus Madison, in terms of procedure, is probably the most important case ever, because in it, the court said, when there's a fight between different branches of government, we're the one who makes the decision. Not you, us. Congress can change that if it wished. But I think it was Suzanne alluded, and perhaps others will, that just because the court rules doesn't mean it's right. It's not, as we say, God's lips to their ears. In 1856, Dred Scott, not a school case, the Supreme Court said that African Americans only counted as 3/5 of a vote. They were not full people. Plessy versus Ferguson allowed so-called separate but equal, that blacks could not ride on the same railway car. That notion of separate but equal made it to education in 1927 in a case from Mississippi. A young lady whose parents were Chinese wanted to go to the school for the white kids, but was told she couldn't. And then finally in 1943, right in the middle of World War I, the United States allowed people on the west coast of California who were of Japanese origin to be rounded up and put in detention camps. And the Supreme Court upheld that. A little PS, in the Northeast, there were camps like that for people who were of Italian background and of German background. But that doesn't get quite the attention. Having an Italian last name, I had to mention that one. Brown versus Board of Education said it well. Education is perhaps the most important function of state and local governments. And in America, we have a sport that you don't play in Brazil. We call it litigation. We sue each other over everything. People get divorced, and they sue over who gets the dog, or the bird, or the vacation home. And I come from an area that is particularly litigious, New York and the Northeast, Mike's up in Boston. If you look at somebody funny, you get sued. But I will say, by the time cases get to the US Supreme Court, the lower courts have done a pretty good job of sifting through the issues. They don't too often take cases that are of minor significance. By the time it gets there, they've gone through a third round of litigation, usually at the Supreme Court. There's serious issues. Until the mid-1970s, there was more litigation on desegregation than anything else, but religion now far outpaces that. In fact, I was at a conference in Boston, AERA one year, and I made the comment that the Supreme Court has given up on segregation. And somebody in the audience took great offense at that. And I say it kind of tongue-in-cheek. I was the token white guy on the panel. I think Suzanne knows some of the people, John Harris, Frank Brown, and a guy by the name of Ray Contreras, who's ill and retired. I was the only white person on the panel. They jumped to my defense. They said, he's right. The Supreme Court can't figure out what to do between de facto and de jure, certainly de facto, so they've kind of thrown up their hands and let it be. Religion is litigated tremendously. 1947, and again, there's a lot here. If I'm going quickly, slow me, or if you have a question, but I want to try to give you an overview. In 1947, a case from New Jersey. The state of New Jersey reimbursed parents for the cost of, 1925, Pierce versus Society of Sisters, allowed non-public schools the right to exist. The state of Oregon passed a law which said the only way kids can satisfy compulsory attendance is if their parents send them to public schools. Two non-public schools argued and they said, hey, under the 14th Amendment, that deprives us of our property without due process of law, and the Supreme Court agreed. About 15% of kids in America attend schools that are non-public or private. And of those, 85 to 90% are religiously affiliated. The Roman Catholic was the largest. When I was a child, 85% of kids in America who went to a religious school went to a Catholic school. Now that percentage is around 40. The number of Catholic schools has dropped, other Christian schools have grown. In 1947, the first case involving the First Amendment. I didn't put a slide up there, maybe I should have, but the First Amendment to the U.S. Constitution reads, Congress shall make no law respecting an establishment or regarding establishment of religion or prohibiting the free exercise thereof. If I asked Mike or Suzanne to answer that question, we'd be here for hours. The court doesn't know what it means. How are we going to know? The court fights not so much about the meaning, but based on the perspective that different judges bring to the table. And in this case, the court created a theory. It's kind of like the Santa Claus theory. I hope I'm not making anybody feel badly, but Santa Claus really doesn't exist. We call it the child benefit test. And it's if you do law and contract law, I kind of describe it as akin to a third-party beneficiary. The state allowed parents to be reimbursed for putting their kids on buses to send them to school. Yes, the school benefits from tuition, and the parents have their choice met, but we say the child is the one who benefits the most. And that's a way of allowing religion to be aided. In 1947, that was Everson. In 1968, the court extended that, allowed textbooks to be loaned to all kids in schools, no matter where they attended schools. One of my cartoons, this is one of my favorites, if you could read it. It's a little boy with a halo. There's a man and woman with a halo. Up in the corner it says, Happy Birthday, Jesus. And the little kid says, what a jip. My birthday's always on Christmas. Do you ever know anybody whose birthday's right around Christmas and they feel they're gypped in that regard? The all-time case on religion is something called the Lemon test. It has a three-part test, as you can see behind me: purpose, effect, and entanglement. I've been a professor since 1989, and I'm still trying to figure out what that means. But the Supreme Court doesn't know what it means again. So that's part of the fun of being in education law. There's always something new. I'm going to skip over some of the other cases in the interest of covering other topics. Here's the next issue that's very important in America is, should people be able to pray in school? So kids called into the principal, he's in trouble. He said, honest. When I said Jesus Christ, I was swearing. I wasn't praying. In 1962, in a case from New York, the Supreme Court said school officials cannot say a prayer before the school day starts. The prayer read, Almighty God, we place our trust in Thee. We ask Thy blessings on us, our parents, our teachers, and our country. Not much of a prayer, but the court said the power of the state is selecting that, so it's no good. The next year, there was prayer and Bible reading. The court said anytime prayer and religion come together, there has to be a secular purpose, and there's got to be a principal primary effect that does not advance religion. By praying, right away there's a religious purpose, so that's no good. Suzanne and I were talking, I think it was last night at dinner, about what cases would be a top 10 list of cases, and these both dealt with prayer. Levi Weissman said no prayer at graduation, and Santa Fe said no prayer before American football. Brazilian football or soccer is played, but in states like Texas, football is a religion. People really get into it. If you're a sports fan of American sports, read a book called Friday Night Lights. It's about 25 years old, but it talks about all the corruption in high school football, how coaches were fired to get kids to be on teams, just phenomenal. Another Wizard of It to end religion, little kids walking down the street says, they threw me out of biology class. And the parents say, why? And he said, for bringing a praying mantis to school. Kind of a play on words on the bug. I have about 15 minutes left, I think. Is that about right? 15, okay. Here's some cares on other religious activities. 1968, Suzanne alluded to Arkansas before. Suzanne and I have a friend who teaches there. We call it Arkansas as kind of a bit of a joke. Whether at a university or an elementary school, the only thing a biology teacher could teach was the biblical notion of creation. You could not teach evolution. I have a theology degree, and I ask you, when did God create? Well, first line of the Bible. God said, let there be light. When did God create the sun? I think it was the third day. So how do you get light without a sun, if you want to take it logically? I know if God's God, God could do what God wants. But it's not meant to be taken literally. Mergens is a case from 1990, was originally designed to allow religious clubs to meet in public schools. And one of the major proponents was a guy named Jerry Falwell. People used to wear on their cars or put on their cars bumper stickers that said the moral majority. Other people said the moral majority is neither. But Jerry Falwell wanted prayer and Bible study club, and based on the language, it's absolutely the right decision. LGBT clubs are forming, and they have the right to form under that same statute. Jerry Falwell is probably spinning in his grave at the recognition of that happening. Some other cases dealt with use of public facilities. I'll skip over that. Science class, little girls looking down at the frog. Did you ever dissect the frog in biology? The frog looks up and said, surely you could find this information online. Student rights. I teach online, as does Suzanne. And one of the questions I ask my students in the context of discussion, do students have too many, not enough, or Goldilocks-like, just the right amount of due process? Goss is the high watermark case of student rights, I think everybody would say. In Goss, the court said if you're going to be out of school for 10 days or more, you have a right to a due process hearing. Very different than the kind of due process hearing that I think Mike's going to talk about, at least in part. This one is whether you stay in school. His deals with educational. They're both fairly contentious, but big issues. Ingram v. Wright, not much of a case anymore, but it deals with corporal punishment. Mostly the American South believes in corporal punishment and still uses it. I will tell you, corporal punishment is illegal, but it can be extremely gratifying. Just be careful who you use it on. New Jersey versus TLO dealt with searches of students' property, lockers, even searches of their persons. It's been applied by lower courts close to 500 times, and schools win about 80% of the time, particularly in this era of dealing with school safety. I'm very fortunate I get to travel. Last week I was in China. I go home Thursday night, get home Friday. Saturday I go to Nova Scotia, and I'm talking in a presentation about the Fourth Amendment. I'm going to do a whole hour on search and seizure in American schools. It's that big of a topic. I used this one in Sao Paulo the other day. Someday, the not too distant future, it'll take a village to discipline a child. I don't know what it's like in Sao Paulo, but when I was a kid, if my brother came home from school and told my mother that the nun hit him, went to Catholic school, my mother would automatically hit him again. He must have done something wrong. It took him a couple of years to realize, don't tell Mom. Now, if a kid gets criticized, the parents come in and yell at the teacher. It's never my child. I think the cart is leading the horse, as we say. Student rights to due process again. Acton v. Vernonia, the first case, and Earls versus Potawatomi dealt with drug testing of student athletes. By the way, if you're interested, write this down, yourinluck.com. yourinluck.com. I was on an airplane flight 15, 20 years ago, I think from Paris to the U.S. after Bosnia. Guy sat next to me, drove trucks for the U.S. military in Iraq. If you go to urinluck.com, they will sell you overnight clinically pure urine and any kind of pill you want to mask the effects of any substance that you've used. So if I know that, you got to know kids know it. Why waste the money in a sense? but the Supreme Court upheld drug testing. But in a great line from Justice Clarence Thomas, he wrote, expressing no opinion as to the wisdom of this policy, we uphold it. I think he was saying, this is dumb. But if you want to do it, you're the board. In Safford, a case from Arizona, the court finally struck down and validated strip searches of kids. Think about it. Teachers have had children remove their clothing, looking for drugs typically, or maybe a weapon. Real dumb idea when you think about it. Here's another cartoon. This guy was a great cartoonist. He passed away of a brain tumor back in the late 1990s. So there's a kid standing in front of the Supreme Court. You notice the one with the scrunchie for Justice Ginsburg. So is it now okay, like if I pray in school, to pass my drug test? Kind of pokes fun at two different issues. Another high water mark, and if you get a chance to come to Cleveland this year, Suzanne's president of ELA, the American Educational Law Association, I was years ago, we're having Mary Beth Tinker come and speak. Mary Beth and some of her friends were put out of school for wearing black armbands, protesting American involvement in Vietnam. If you've ever seen an older movie, an older American movie called The Godfather, at the end of Godfather Part 1, when they're burying the Godfather, first I have to say my grandparents are extras. They're buried in that cemetery. But they wore black handkerchiefs around their arms. And I asked my father, who was born of an Italian family and grew up in New York City, whether they really did that, and he said, yes, they did. So wearing something black was a sign of mourning, but you got to wonder how much disruption it caused. The Supreme Court said it didn't really cause much disruption. Don't know if you knew him. Suzanne should have known a guy by the name of Gus Steinhelber was a big education lawyer in the country. To his dying day, he said it was disruptive. Well, basically the Supreme Court said neither students nor teachers check their rights at the schoolhouse gate. And the court went on to say, and that's written in legal, to translate it into English, unless what somebody wears will cause a reasonable forecast of material and substantial disruption, you can't stop them from wearing it. With a kind of PS from later cases, unless you have a uniform policy in advance. So that deals with things like piercings and hair color and T-shirts and the like. It's the first of 3 or 4 cases. Here's another kid getting in trouble. Kid gets sent to the dean's office or the principal's office. I said the S-H-I-T word. I said the F word. In American schools today, if I said Christmas, you could get in trouble for saying that, a little bit of tongue-in-cheek. There was an incident in New Jersey. I know a few of you have visited New Jersey, and I offer my condolences if you did. But there was an incident in New Jersey where a teacher came to school wearing a green sweater and red pants. She was told she could not wear that to school because those are Christmas colors. It was never litigated, but we have a lot of litigation that I call get a life. There's a case from Ohio. If any of you are college basketball fans of American teams, Duke is the Blue Demons, I think, or the Blue Devils. My son went to law school there. A case from Ohio, a kid painted his body blue and ran up and down the sidelines at games. Somebody actually filed a lawsuit saying that promotes devil worship. The court said, get a life. Bethel v. Fraser talks about things that kids can say at school-sponsored events. Kid got up and gave a speech. There was a lot of double entendre. I know a man, he's firm in his pants, he's firm in this, all kinds of sexual metaphors. The kids in the gym are going crazy. The court said it different from Tinker. This was an unsuspecting audience and it was not political. They could limit his speech. Hazelwood v. Kuhlmeyer, 2 years later, dealt with a student newspaper. If you remember nothing else about what I say today, if you remember anything, I'd recommend you remember the last 2 lines of that. As long as the actions of school officials are rationally related or reasonably related to legitimate pedagogical purposes, you win. Do you have some common sense relationship between the law and your policy? I go overseas quite a bit. I taught in Mallorca, Spain for 18 summers. I travel. That's consistent with all the international documents. Show some rational relationship to what you're doing, and you're going to come out on top. Morse v. Frederick is really a footnote, but the Olympic torch for the Winter Olympics was running through Juneau, Alaska. And this kid who was a bit of a troublemaker positioned himself right where the camera from CNN was, and they put out a banner that said, "Bong hits for Jesus." The principal saw that and said, "That's about drugs. Take it down." Long story short, the Supreme Court agreed because she had the notion that it was drugs. He argued it was not under your control. It was a parade on the street. But the school argued, we allowed you to, well, he came late. We allowed all the kids to leave school and be under the supervision of their teachers while the parade went by. So that's close enough that she had the authority to do that. Suzanne talked about Title IX a bit. I'm just going to pass real quickly. The first two cases dealt with student-to-student sexual harassment, peer-to-peer. Franklin versus Gwinnett, 1990. The court uses, we call it a euphemism. I can't think of an easier word. Not really honest. The court said a teacher engaged a student in, quote, non-consensual sexual relations. Where I come from, that's called rape. Court said Title IX could be used for the first time in a school setting to go against a teacher, rather, not a peer. In Davis v. Monroe, Lago Vista, 6 years later, a teacher did have sexual relations with a student, but when school officials found out about it, they fired the teacher, who was put on trial, and he went to prison. Court said that's different than the first case where they kind of looked the other way. Suzanne alluded, Davis v. Monroe deals with peer-to-peer sexual harassment. The test in Davis v. Monroe, I don't know whether Mike's going to talk about it, has been used in bullying, including cases of special education, involved in religious discrimination and in racial discrimination. If the harasser and the one who's being harassed are in the control of school officials, and they're deliberately indifferent, meaning I told you about it, and you said, oh, don't worry about it, and the harm is severe and pervasive and there's some other elements, then the school can be liable. It's a pretty good test, but it's only as good as the people who implement it. Special ed, I'm going to skip over these, so I think Mike's going to touch on some. The one comment, Rowley was the first case ever. This case, the last year, deals with the level of services. Need an extra parentheses in there. He's going to mention that. Teacher rights, one case real quickly, then I think I'll about stop because I'm running out of time. Cleveland Board of Education versus Loudermill kind of does for teachers what Gosh did for students. If a teacher has tenure, before that teacher's tenure contract can be eliminated, the teacher must be given notice, an opportunity to respond in the presence of a fair and impartial third-party decision maker who makes a decision based only on the record that's at that hearing. You can't bring outside material in. Some of the free speech rights parallel students, so I'll let that be for now. Except there's a good cartoon from Mark Twain. You've censored parts of Huck Finn, and they censor his response to people who didn't want that book in school. Teacher unions, Suzanne and I were talking about this the other day. There's a major case. We're waiting for the decision. It'll probably come down in June, whether unions can require non-members to pay fees for being members of unions. If the unions lose, it will hurt the unions big time because they'll lose a lot of money. School finance, the last case I alluded, education belongs to states. I know that's a pretty quick and dirty, as we say, overview of major Supreme Court cases. 30 seconds on a case does not do justice to them. But what I hope I've given you is some idea of the wide range of issues that we've litigated on. As I say often when I speak overseas, I don't want people in Brazil following American law. I don't necessarily want America to follow Brazilian law, but I hope you can learn from our mistakes, learn from what we've done wrong, and learn from what we've done right. As I mentioned before, whether you agree with the court or not, every one of those is tough decisions. I don't think there are any unanimous decisions there's 9 justices. I don't think there's any unanimous decisions. One judge changes, one justice changes the law for the country. So as we come together to do this and we might develop partnerships, I think we learn from each other and hope that gives you some idea of just how much litigation in the states doing with education law. With that, I think I passed the baton to Professor Raineiri. Are you next, Nina? Or Michael, I'm sorry. Thank you.
Bom dia. Well, they're bringing up my PowerPoint. I want everybody to stand up. Stand up. We've been sitting for 2 hours. When we first came in and Professor Monica and Suzanne were speaking, everybody was sitting up. Then Marcelo, people start slouching down. By the time we get to Charles, everybody's laying back like this. So stand up, stretch, wake up. Now you can sit. Get the blood flowing again. Okay, I think we're ready. I just want to start by expressing my gratitude for being here. This has been my first trip to Brazil, and I love it. And it's been great. I really want to thank Professor Monica for bringing us out to Ribeirão Preto. Thank you. Thank you. So, as you heard when I was introduced, my title at Harvard Law School is Clinical Professor of Law. I want to explain what that means. So in the US system, we have a type of legal education called clinical legal education. And this means that primarily, although I do some teaching in the classroom, the way that I teach law students is by having them actually represent real clients. So we are out doing legal work together. They practice under my law license, so if they mess up, I get my license taken away. And so I want to share with you the kind of work that I do. I teach in a program called the Education Law Clinic at Harvard. And we teach law students primarily in 2 ways. First, we represent actual families in the special education system. Special education is the education of students with disabilities, as you probably know. So my students and I represent low-income or poor families who cannot afford to pay for a lawyer, and we litigate against their school district to make sure they are getting their legal rights and entitlements to education upheld and respected. The second thing that we do is we do a lot of legislative lawyering. So Boston, where we are located, is the state capital of the state of Massachusetts. And we take our students down to the State House and we lobby with representatives and senators to get laws passed and funding appropriated so that schools can do the best work possible for students. So unlike my colleagues Suzanne and Charlie, I'm not going to talk about a lot of Supreme Court cases or really any legal cases. I'm going to talk about how these cases actually work for real families. So we might have a Supreme Court case that gives families rights. We might have a law that gives them entitlements. But how do those rights and those laws actually trickle down to make a difference in the lives for real families and real students? Because I have to every day make these laws work for my clients, and I want to give you a sense of what that looks like in the US. So we'll start with special education. If we have time, I'll talk a little bit about school discipline, but I think maybe we won't have enough time. We'll see. So special education is a good example of federalism in the United States, because we have a federal law called the Individuals with Disabilities Education Act, or IDEA. Suzanne referenced it. And it sets the floor for what all states must do for students with disabilities. But states can go above and beyond that floor. And I'm fortunate enough to work in a state, Massachusetts, that has expanded in many ways on what the federal minimum is. I think special education allows us to see the trade-offs associated with federalism. There are many benefits to it, and Marcelo talked about some of those. It allows each community to come up with the policies that work best for it. But there are trade-offs. Students in Massachusetts have more rights than students in Indiana, where Suzanne teaches. Is that okay? Should you get more in Massachusetts than you get in Indiana or Texas or Arkansas? Maybe yes, maybe no, but these are the trade-offs of federalism, right? I think that special education also gives us a window into a question that's important for today, which is high-quality education. It lets us ask the question, do we really want high-quality education for all students? Are we willing to make a commitment to achieving that? Because if we are not doing so for students with disabilities, then we are not doing so for all students. So I'll share a little bit with you about how the special education process works, particularly in my state of Massachusetts. And I'd like you to be thinking about, is this a system that you think would produce high quality education for students with disabilities? I want to start by sharing with you the eligibility criteria for special education in the United States. So the law gives special protections and entitlements to students with disabilities, but who gets these entitlements? Who qualifies? Essentially, we have a four-part test. The first is that the student has to have a disability. Well, right here, you can see that parents are at a disadvantage because who diagnoses a disability for a child? Not the parent, a professional, a doctor, a psychologist, an educator. So before you even get your foot in the door, the family has to have access to a professional opinion that says the student has a disability. Also, this introduces the challenge of stigma. If, as the threshold for getting special services, you must be labeled with the disability and carry that label with you into school, that can produce stigma. And so we have to be very careful about giving extra services where they're needed, but not stigmatizing students. The second part of the test is that the student has to be failing to make progress. If you have a disability, but you're doing very well in school and making friends and having good relations with your teachers, the law is not going to give you special services because you're already doing very well. The third prong is a causation prong. It has to be the disability that is causing your failure to make progress. This is something that we often litigate in our cases, where the school district is arguing that it is not the child's disability that's causing the failure to progress, but something else. Can anybody think of a reason that a school district might think a child is failing to make progress other than the disability? What might the school district say? Well, the school district wouldn't admit to discriminating, right? That could be the reason under the surface. But something that a school district might say is, we acknowledge you have a disability, we acknowledge you're not making progress, but we say that you're just unmotivated. You just don't want to learn. And so that's why you're failing, not because of your disability. With older students in high school, sometimes they use substances, marijuana, other things. The school district might say, well, that's the reason you're not progressing. It's not because of your disability. And yet we know that oftentimes the reason that students might use substances is because they're depressed or they have anxiety or they have underlying disabilities. Another problem that we encounter a lot in the US is that sometimes students with disabilities don't go to school. And a real trend that I'm seeing in my practice right now is students who are refusing to go to school because of very high anxiety. It's because of a disability that they're not going to school, not just because they want to stay home and watch TV. And so the school might say, well, you're not coming to school. We're giving you a great education. You're not choosing to access it, so we're not going to give you special services. We then have to make the argument back to the school, no, we have an expert opinion. This is disability related. And therefore you should go further in providing services to the student. The fourth is a simple one. We don't litigate this very much. It's simply that you have to show that the student can benefit from special education. The student can benefit from accessing the services. I have a timer here, and I want to keep track of my time. So that's the test. If you meet all 4 prongs, you are eligible for services. Well, if you're eligible, what do you get? What does the law entitle you to in the United States? So the legal standard is something called free, appropriate public education. Well, what does that mean? The law breaks FAPE, we call it, down into 4 major categories. The first is accommodations. Maybe you need to sit in the front of the class because you can't hear well if you sit in the back. The law would entitle you to that accommodation. Another guarantee is something called specially designed instruction. Maybe you need a teacher who has been trained to teach in special ways that most teachers are not trained in. The law would entitle you to be taught by such a teacher if that is your need. We also guarantee something called related services. Maybe you need counseling. Maybe you need speech therapy. Maybe you need occupational therapy. Any of those things that you need, if we can prove that you need it, the law would entitle you to it. And the 4th major category is placements. Now, in the US, we have a different standard with respect to inclusion than many other countries. In some countries, the requirement is that students with disabilities are included in the same classroom with everyone else. In the US, we do it a little different. The legal entitlement is that the child has a right to be educated in the least restrictive environment in which they can make progress. So if the experts determine that you cannot make progress in the general education classroom, then you can be placed in a special classroom, or in the most extreme circumstances, in a separate school, or even a residential school where you live there because you need support 24 hours a day around the clock. This is the range of placements that you can be placed in. Many of the parents who come to me for legal help are seeking a more restrictive placement from their child's school district because their child has been in the mainstream, has been in the general education classroom, but nobody's attending to their needs, and they want their child to be placed in a special class with a specially trained educator who understands how to teach them well. I think this is a very tricky area in special education law because the ideal would be that we have created schools in a way that they can serve everyone and nobody has to be separated or segregated from their peers. But in the US, this is not a reality. And so I sort of feel that my clients and their children should not have to suffer while we work on improving the whole system. But if there's something that can exist today that can help the child learn, we should give it to them. But this is a debate. This is what special education provides. This is the process that a family would have to go through to get special education for their child. And I think it's important to focus on this because it shows you that simply articulating a right at the federal level or even at the state level is not self-executing. It doesn't mean that anything happens on the ground. There's got to be a process that the family goes through to access and exercise the rights that the law gives them. And as you look at this process, I want you to imagine that you are a single parent with 2 or 3 children. Maybe all of them have disabilities. Or imagine that you're not a single parent. Maybe you have a spouse, but you're working 2 and 3 jobs just to earn enough money to provide housing and food for your family. Or imagine that you're an immigrant to the US and you don't speak English. Imagine that you're an immigrant from a country where maybe there isn't even a well-established education system. Maybe you didn't even go to school. Now you're in the US and your children are required to go to school, but you don't know how it works. Imagine you're one of those families and you're going through this process. Very, very difficult to navigate. Question?
Because provide the parenting conditions to their kids?
Yes, I'll start with your second question. If you are a family that has means and you are not satisfied with what the public school is providing to your child, you can go and enroll your child in a private, specialized school and then file suit against the government to be reimbursed for the money that you pay. My clients cannot do this because they don't have money to pay the private school. So their child has to stay in the public school until we go and do a case and get their child access to something more specialized. In order to try to equalize the playing field between wealthy and poor families, the courts, and this is not in the law, the courts have done this, have come up with a remedy called compensatory education. And that says that if my client is sitting in an inappropriate school for a year while we do a case, and then we win and we get the student a more appropriate placement, the school district can be required to give extra education to make up for the year that the child was getting something inappropriate. Now, that's the best that the courts can do to equalize between the families that can go pay for it themselves and the families that cannot. But the question I would throw back to you is, can you ever make up for that year? The year that the child was sitting in an inappropriate program not learning. You can provide lots of extra education, but you can't make up the time. Now your first question was, say again? Oh. No, there's no levels. What we have in our law is categories. There are about 10 disability categories. I may not be able to remember them all off the top of my head, but I can tell you some of them. Autism, intellectual disability, health impairment, communication disorder, emotional impairment, learning disability. What other ones, Suzanne? Specific learning disability, and there are a few others. So you have to fit into one of those categories to qualify, but there's no levels. Judging the severity of the child's disability is left up to the discretion of the educators who are educating them. Okay. So let's just explore this timeline a little bit. The first step is that someone has to refer the child for an evaluation. And here immediately we get to a difference between the states. In Massachusetts, if the parent requests an evaluation by an expert at the school, they are entitled to receive it as a matter of right, no questions asked. The only threshold is that the parent has to have a genuine concern about their child. That's always the case. In some states, the parent has to argue that the evaluation is necessary. Well, how can you argue that when an evaluation hasn't been done yet? It's sort of a tautology. How can you show that the child needs an evaluation when there's no evaluation showing that the child might have a disability? So this is one way in which in Massachusetts we are more fortunate than in other states. Once the request for the evaluation is made, and we advise our clients to make the request in writing. It is not required. The parent could simply go in and say to the teacher, can the school evaluate my child? I'm worried that he's not learning. That would count as an evaluation request. But how would you prove that? I'm a practicing lawyer, so I have to worry about how would I prove that in a court that my client asked. The client says, I asked. The teacher says, no, she didn't. Who wins? So much better if you can write down the request, take it to the school, get it stamped, and then we have a document. We can prove the request was made. Once that happens, in 5 school days, the school district responds with a consent form. This is confusing to many of my clients because they say, I already requested the evaluation, why do I have to sign consent? So sometimes they get the paper and they just throw it away because they don't understand. But this is a part of the process. On the consent form, the parent in Massachusetts gets to request every single evaluation they would like. Maybe they want psychological evaluation, educational evaluation, speech and language evaluation, occupational therapy, physical therapy, and any box they check, the school must do it. This is not true in every state. So the consent form is actually very powerful because it allows parents to request any evaluation they would like. The parent returns the consent form to the school. In Massachusetts, the school has 30 school working days to complete the evaluation. So these are days that school is in session, not weekends, not holidays, they don't count. 30 school working days. In the federal law, it is 60 days. So if you're a student in other states, you have to wait extra time for the school to complete the evaluation. In Massachusetts, 30 days. Then, within 45 days, school working days, of the receipt of the parent's consent form, the school must convene a meeting. We call it an IEP meeting or a team meeting. IEP means Individualized Education Program. It's a document that the school develops when a child is eligible for special ed, and it lists all of the accommodations, special instruction, related services, and the placement that the child will receive. And it's a contract between the family and the school district. It's a legally binding document. This document is developed by a team of people. It includes teachers, school administrators, somebody from the school district that has authority to commit resources. It's not okay to come to the meeting and they say, oh, well, we'd love to give you this service, but the person who's in charge of that isn't here, so we can't make any promises. The law requires that person to be in the room. The parent is required to participate, by which I mean the school is required to allow the parent to come. Sometimes the school district will try to hold the meeting very quickly. They'll tell the parent, we're meeting tomorrow at 3:30, you must be there. Maybe the parent works, they didn't plan ahead. So as a lawyer, I would come in and say, no, we're gonna postpone the meeting, the parent can come next week, and you need to do it at a time when the parent can be there, and we have the right to assert that in the US. The student is allowed to attend, but does not have to attend. The school district is obligated to invite the student to the meeting beginning at age 14. Sometimes it's a good idea for the student to come. Sometimes it's too hard to sit and listen to all the adults talking about your disability and all the ways in which you're not making progress. That can be very hard for a student. Some of my older clients have very powerful voices, and they know what they need, and they want to come to the meeting and tell. And that is the most powerful voice in the meeting, when the student can actually speak and say what they need. But not everybody can do that. These meetings are considered legal hearings. There is no adjudicator, no judge, no hearing officer. The school district holds the cards. They hold all the power. So what we do in our clinic is usually we obtain an independent evaluation. Because I teach at a well-resourced university, we can pay to have our children go and evaluated by top experts, neuropsychologists and others, to compete with the evaluation that the school does. Often the evaluation done by the school district, very cursory, very minimal. They make no recommendations, make no diagnoses. So if you're sitting at the table at this meeting and the only information guiding the discussion is the evaluation that the school did, you may not get a lot of services. So we have to bring an outside expert to the table to say, no, I spent a lot of time evaluating this child and they actually have significant needs. Many parents cannot afford this. An evaluation, a good, solid neuropsychological evaluation, costs between $3,000 and $4,000. Most families cannot pay for this, especially if they are paying for a lawyer. Their money is going to the lawyer, not to the evaluator. I should say, in our clinic, all of our legal services are pro bono. We do not charge our clients. They couldn't afford it. And we're fortunate enough to have a budget that allows us to bring these evaluations in. If the student is found eligible at the meeting, the school produces the IEP. Then the parent responds. Maybe the parent likes everything that's in the IEP, they accept it. Once they sign it, it becomes legally binding. But maybe the parent likes some things that are in the IEP, but they don't agree with everything. So we have an option where the parent can accept in part, reject in part, and then they maintain their right to go to court on the pieces that they disagree with, but the school must implement all of the parts that are agreed to. Many parents don't understand this. They think, and the schools tell them, well, you either have to accept it all or reject it all, and so parents will reject the whole thing, even if there's just one part they don't agree with, but because they reject the whole thing, their child gets no services. Without a lawyer to explain what these choices mean, a lot of families are at the mercy of the school districts. If the parent rejects any portion of the IEP, they do have a right to this independent evaluation that I described, and if they are a low-income family, they have the right to have the school district pay for the outside evaluation. This seems very good, but in practice, it doesn't always work well. I'll come to your question in 1 second. There are laws that establish how much money the school district pays for the evaluation. And these rates are way below market rates. So all the good evaluators charge $3,000 and $4,000. Maybe the school district pays $1,100. You can't get any of the good people. You get people at hospitals that do many evaluations. They see the child for a few minutes, write something up. Not much better than the school evaluation. So it's a good right, but in practice, because the rates are set so low, it doesn't often help many families. After you go through all of this process that I've just described, this is all just at the school level. No courts, no litigation yet. If you go through all of this process and you don't agree with what your child is getting, then you can go to court. We have first an administrative level. In Massachusetts, we have an agency called the Bureau of Special Education Appeals. And you file a complaint, and you can have a due process hearing. These are just like court trials. There's discovery between the parties. There is evidence, witnesses, testimony, and a hearing officer will issue a decision on whether what the parent is requesting is appropriate or whether what the school district is proposing is appropriate. In Massachusetts, we're very fortunate because the administrative law judges who hear these cases, they have to be lawyers. Not true in every state. You can have judges hearing these cases who have no legal training, who don't understand the law. But in Massachusetts, you must be a lawyer, and you must have experience in education or disability rights or special education. So our hearing officers are expert. They understand the law. They understand how to educate students with disabilities. In some states, the hearing officer might be a superintendent from a neighboring school district, somebody who's very much inclined to go along with what the school says. It might be a professor of education at a university, but somebody who doesn't know the law or doesn't actually teach in public schools. So we have a very good hearing system in Massachusetts. We publish the decisions of all the hearing officers, which are written. So as a lawyer, I can go search a database and bring up all the prior cases that are similar to my case. And I know what the decisions the hearing officers have made. In many states, the decisions are not written, they are not put online, so you have no way of knowing what the common law of special education is in your jurisdiction. I want to point out one case, Supreme Court case, that has had a major impact on my work and on the community of clients that I represent. It's a case called Buchanan. And it's a case where the Supreme Court decided, let me back up, one of the other rights in the federal law is that if you are a lawyer and you represent a family and you do go to court and you prevail, you can have the school district pay your attorney's fees. What this part of the law enabled was a lot of small-time practitioners, private attorneys, to earn a living representing families in special education, even low-income families, because you could take a case without getting paid up front, but you know if you do a good job and you win, you can get your fees paid by the school district at the end of the day. Often in these cases, just like much civil litigation in the United States, the cases are settled. They don't go all the way to trial. Trial is very expensive. It takes a lot of time. It's much better if the parties can negotiate and come up with a settlement. Well, for many years, attorneys could still get paid for some of their time, even if the case settled. But the Buchanan case that I mentioned set a new standard and said the only way you can get fees paid as an attorney is if you go all the way to trial and you win. No fees paid if you settle. Well, for 90% of cases that settle, attorneys can't do this work anymore because they still put a lot of time in and they get no pay at the end. So what this meant was all of the small practitioners who could represent families in special education, they've got to go work in other areas. There's now a vacuum. There's no legal representation for families anymore unless you are a wealthy family and you pay a very expensive attorney at a law firm, or you're one of the few families that finds your way to my clinic or to other pro bono legal services. But for all the other families out there, even middle-income families that are doing very well, you can't afford an expensive attorney and you don't qualify for legal services because you're not poor enough. So you have to go through this whole process on your own without any legal guidance. So Buchanan has been a very, from my point of view, harmful case because it dried up the legal market in special education. There was a question over here.
My question is this independent evaluation that you hired, it substitutes the school evaluation completely, or it can be argued by the school that it's requesting too many things?
Yes, you are right at the heart of the matter. This is what we litigate over. We call special education a battle of experts, sort of like a tort case or a medical malpractice or something. So just because we get the independent evaluation, the school district does not have to go with it. They just have to consider it. But sometimes if it disagrees with their evaluation, this is what we're taking to litigation. And the hearing officer is deciding whose evaluation do I think is better. This puts parents in a very disadvantageous position for a reason that might be intuitive to you. The school's expert has access to the child every day when they're in school. They can go observe the child in the classroom. The private expert sees the child one time in their office, not in the school setting. And so the school often argues, well, yes, you know, this doctor has very high credentials, they're very expensive, but they saw the child once. Our expert sees the child every day. We know the child much better than this other person. And so that's a hard hurdle for us to overcome in our cases. I'm almost at the end of time. Maybe a couple questions more and then I'll conclude.
Okay, I have two small questions. First one, after the evaluation and all the process, and the student is part of the special program or includes this special abilities and ways to teach, does he get a special evaluation? Because we have a problem here in Brazil. I'm a lawyer too and professor in private university and doing my master's in education. And I have teachers with special education and they complain that they get in all the same system and they have the same evaluation of the normal and with normal abilities and everybody else. And this problem we get in Brazil, a second problem, that is the progressing the students. We have a system that we have a free access to the other grades and series. And at the end of one cycle of education, they get blocked or not to the next one. And the teachers that deal with the special education, they complain a lot that their special students, they get included with the same system that it's not fair for them. And educational law, do you have that as a grade in your universities? Like your students of law get this as a grade?
Okay, I will try to answer both questions quickly. The first question is a hard question to answer, but I'll give one example that I think goes to your point. So in the US, as you may have heard, we have a lot of testing, a lot of standardized testing. In Massachusetts, there's a test you take in 10th grade that you must pass in order to get your diploma. You cannot get a high school diploma if you do not pass the test. Students with disabilities, to get their diploma, have to pass the same test as everyone else. Now, on the one hand, we say, well, that's good. We want to hold everybody to the same standard. We don't want to diminish what we expect from students with disabilities. We want to bring them up to the same standard as everyone else. And so I think that's good. But there are many students who will never sit and take a pencil and paper test and be able to achieve at the same level. Do we want to say that they should not have access to a diploma when that is the baseline for employment and for other opportunities in our society? So it's a very tricky question, but it's an example of what you're saying, which is to sort of progress or to get a credential or to move forward in the education system. Students with disabilities have to pass the same threshold as other students. So it creates tensions. I don't know what the right answer is. In terms of education law, at Harvard, where I teach, we have the clinic, which I mentioned. Students receive academic credit for their work in the clinic, so it goes toward their law degree. In addition, there are courses on education law that are elective courses that students can take, and they get academic credit for those courses. It is not required to get your law degree. Yes. Yes. So I'm over time. I should probably stop. But thank you for your good questions. And hopefully I've given you some kind of a concrete sense of how one of our major federal laws actually translates. Okay. Okay. If Professor Monica says it's okay, it's okay. Yes. Yes. Yes, so the question is the federal special education law binding on all of the states? The answer is yes, and I want to explain to you briefly why. You heard Professor Charles tell you that there's no fundamental right to education in the US, and that the power to regulate education was reserved to the states. So if the states have the power, how is it that the federal government can make them do this law? We have a section of our Constitution, maybe you've heard of it, it's called the Spending Clause. The Constitution empowers our federal Congress to spend money. And the courts have said that if the Congress spends money and gives it to the states, it can attach conditions to the receipt of that money. Special education is an example of what we call spending clause legislation in the US system. So what Congress does is it says, we would like to give you money, states, to help you educate your students with disabilities. If you accept this money, you must follow all of these requirements. Yes, No Child Left Behind is another example of spending clause legislation. So theoretically, a state could say, well, we don't want to do this, so keep your money, we're not going to take it. But there's actually been some cases challenging that as well. And for the most part, I mean, all 50 states accept this money, and all 50 states, and the District of Columbia, have to, which is our federal district, have to implement this law. But it's just the bare minimum. Yes, the decision of the Bureau that I mentioned is binding. The school must implement it. The school or the parent can appeal, and that's how you get into the federal court system, and you can go all the way up to the US Supreme Court. Okay, Obrigado.
Thank you, Professor Michael Gregory. It's a new idea here about clinics and clinics operating near the universities and the law schools, especially near the law schools. So thank you for the new idea that you brought us and you brought between us. And now, to finish this seminar, I give the word to the speeches for Professor Nina Raineiri. And at the end of her speech, Nina Raineiri will make the sorteio. What's the name of sorteio in English? No idea.
I can do the sorteio in Portuguese. I will offer a book for the students, and we don't know the word in English. How to offer by a donation. I don't know. A lucky person. Well, I'm really very happy to be here. This is my first time at the law school in Ribeirão Preto, not the first time in Ribeirão Preto, but the first time at the law school in the sunny and so beautiful city of Ribeirão Preto. Really very happy. It's both an honor and a privilege to be here with this distinguished company. Thanks to Monica, thanks to Charlie, Suzanne, and Mike. Thanks to come to Brazil. It's not an easy trip. I know you are working hard since Monday. They are speaking every day since Monday and traveling since Sunday, almost traveling every day. Thanks to Marcelo as well. And I'm really very happy to be here and for this invitation to share different perspectives about education in Brazil and USA. And thanks to the faculty as well to be here, and to the students. It's really an opportunity to talk about education law, and I'm also very happy to see you all here listening since 9 a.m. And maybe we can offer an elective course. I learned this an elective course on education law, Monica. And it's an opportunity to begin something different. So it's an idea. In São Paulo, some students ask me for an elective course in education law. It's not common to have elective courses on education law in Brazil. And education is a subject so large. You can learn civil law, criminal law, constitutional law, administrative law, international law, tax law, fiscal law, what else? Contract law through education. Our dean in São Paulo tells me, well, it's so large, the subject, I never imagined it. It's so large. The area is amazing how it is large. You can teach anything through education. So it's really amazing how you can learn through education. It's really amazing. I don't know about Roman law, maybe. How can you tell me about Roman law and education? Could be another field to be explored. So I'm finishing the seminar, and I would like to talk about Brazilian system, especially to our guests. And differently from America, Brazilian system is a hard, centralized system in terms of education, despite the federalism and all our decentralized incumbencies on education. So I would like to talk about our challenges in our federalism system. So I will start saying that in Brazil, the Constitution makes direct references to education. Oh, I need the PowerPoint. Okay. The Constitution makes different references to education, and among all the sources of education authority, federal law is the most important. In fact, the broad legislative education authority resides with federal government, so it's completely different from America. And public-based education is state and local government's responsibility. Therefore, there is no correspondence between who legislates and who executes public-based education. Education system is largely decentralized in terms of education responsibilities, but very centralized in terms, well, when it comes to national education policy and laws. There is something wrong. Who executes doesn't legislate in terms of national educational policy. So, educational incumbencies are distributed among the federal entities. Municipal governments are mainly responsible for preschool and fundamental education. State governments are mainly responsible for secondary education. The federal government is obliged to supplement the local and regional educational budget, thus guaranteeing equal opportunities of access to education. Actually, the federal government has a redistributive and supplementary role, thus guaranteeing equal opportunities of access to education. This means that since the Constitution does not specify priority in terms of federal education incumbencies, its supplementary role applies to all the levels of education in the country. This reveals the cooperation between the three levels of government, since basic education is a common responsibility. The collaboration pattern is once again emphasized in Article 214 under the National Education Plan. The problem is we don't know how this cooperation should work. And this is our first challenge. You heard much about this on Monday. Everybody emphasized this problem. Brazil defined its educational goals for 10 years through the National Education Plan. The plan sets out 20 goals and targets along with broad strategies, which can be implemented and defined by states and municipalities. The challenge is ensuring alignment and coordination between the different levels of government and stakeholders to deliver quality education. And you hear also a lot about this, how difficult it is to coordinate and set the main goals. In this context, several solutions have been proposed. The conception of a national education system similar to the unified health system we have here in Brazil. Tax reform associated with the national education system. New forms of federal interference in the management of educational system, intermunicipal cooperations. I don't know if here in the Ribeirão Preto region you have any intermunicipal cooperation or not, but there are some regions in the state you have, like consórcios and cooperations, and this is something that is really working. But it's not all over the country, only in some regions. and state-municipal cooperations, creation of municipal consortiums, etc., municipal associations, and other forms of territorial arrangements, among others. You talk about these local solutions as well. Well, the other challenge is the non-correspondence between who legislates and who executes public basic education, as I said. And we can see this through the structure and hierarchy of educational system. The incumbencies among this distribution among the states and the federal governments when it comes to legislation. So the federal government legislating through for the whole country, and the states and the local government legislating only to complement the national rules. So the Constitution is very restrictive about the legislative incumbencies for the municipalities, which only have the right to rule about educational matters concerning their peculiar concerns. However, there is a limit to the federal right to legislate on education, as it cannot trespass the boundaries of the legal sphere of action pertaining to the other government entities. So let's move to the financing issues, our third challenge. In order to support all the above-mentioned education commitments, the resources are guaranteed by a binding percentage of tax revenues provided by Article 212 of the Constitution. The Union shall apply no less than 18%, and the states, the federal district, and the municipalities at least 25% of the tax revenue annually. These percentages are mandatory, and when not applied accordingly, interference from the Union and the states, and likewise the states and municipalities, is permitted by the Constitution. In 1996, the Constitution was amended to impose an obligatory allocation of 6% of these resources in the universalization of fundamental education and better salaries for teachers. In 2006, the Constitution was amended again to extend these goals to basic education. Both these amendments have created a temporary fund for the maintenance and development of education with a redistributive objective. The former established the so-called Fundef. You heard a lot about this Fundef, and the later Fundeb, Fund for Maintenance and Development of Basic Education, extended cover preschool and basic education, replacing Fundef. More specifically, the financing mechanism used in Fundef and maintained by Fundeb oblige the Union, the states, and the municipalities to invest 6% of the resources allocated by the Constitution, the Union's 80%, and the states and municipalities 23% of tax revenues to the primary and now intermediate education through the fund. The resources of the fund are redistributed according to the number of students enrolled annually in the public schools maintained by each governmental entity, based on a minimal value per student established by the federal government. The Union is obliged to supplement the fund whenever in each state and in the federal district the nationality set minimum value per student is not reached by the responsible government entities. The distribution of the resources will also prioritize enrollments from the 1st to the 8th grade of basic schooling. The core of the idea of establishing a single educational fund, i.e. Fundef and Fundeb, was to rationalize the allocation of public educational resources as well as to distribute the responsibilities and resources among the states and the municipalities as stated in Article 2011 of the Constitution. Fundeb also increased funding by 25% to support the full-day schooling initiative. Spending was increased from 15 to 20 of total revenues from states and municipalities. In addition, both Fundef and Fundeb led to development and implementation of a census of students and schools together and consolidate information. After 18 years of Fundeb, wealthier states and municipalities with higher tax revenue are still able to spend more on their education system than those in poorer regions. So, maintain the inequalities. These findings prove that the equalizations occurs in a minimal level. The inequalities between states remain, and that the challenge is increased spending and efforts to distribute funds more equitably across the education system. Fundeb was foreseen to last 14 years, when the target of 47.2 million students enrolled in basic education is achieved. Recent policies and practice are also foreseen. Efforts have been made to distribute education spending more equitably in Brazil. Various initiatives aim to increase the resources for education, and you have heard about this on Monday as well. 2 laws about royalties from new oils exploration contracts have been enacted. You heard about this, and you heard also about how it won't work at all. The resources of oil are not so good as we imagine, so we don't know how much it will work, and we also don't know how much the other initiatives like the student cost, initial quality, the custo aluno qualidade, how much it will work as well. The other initiative is the National Education Plan. It was enacted in 2014, but the goals also it wasn't achieved. We are 4 years in the plan already. We already have 4 years in the plan, and it doesn't work as well. So as we talk on Monday, in spite of all the initiatives, we are still facing the same problems of inequality and lack of quality, etc., etc. But this is we are still working in this situation. And what to do? What do we have to do? How law can help to face this scenery? How law could help to face the scenery? How the law students could help? What can we do in the law school? How can we face these problems in the law school? This is our goal. This is what we aim to do here in Harvard, in Indiana, in Dayton University. And so in conclusion, what can we do? That's what I ask to you. That's what we do in São Paulo. That's what we want to do here. The cooperation in federalism is one of the key issues we have to study. In this very centralized Brazilian federation, this is a key issue. The experience of Fundeb proves there is much room to improvement. and in this kind of mechanism. And it's necessary, not only the cooperation, but also to invest in teacher education. This is a problem of education schools and education training, teacher training, etc. But I think that in law schools also there are much room for improvement. That's why I told you in the beginning that education is a field we can study many of our disciplines, and in Brazil, education is our main concern. Through education, I'm sure the country could be much better than it is today. So I finish with these thoughts, and I leave Ribeirão very happy that there is a field we can really improve these thoughts. Through education, we could be much better than we are today. So thank you very much for everything.